Hello, and thank you for joining our third annual Day with DISA. Before the session gets started, let's go over a few things. A copy of the presentation will be available to download once the session has ended under the Materials section. If you have questions about the information in this session, enter them in the Q&A section below, and the speaker will answer them once the session has ended. If we don't get to your question, we'll reach out to you at the end of the conference. If you have questions about the topics or trends that are mentioned throughout Day with DISA and how they pertain to your company, and you'd like to reach out to one of our team members directly, hit the chat icon at the bottom of daywithdisa.com and you'll be connected directly with one of our team members. Thank you for attending live. Each of our live attendees is eligible for our prize drawing at the end of the conference. And each session that you attend live increases your chances of winning either a Nintendo bundle or a brand new iPhone 12. Finally, I'd like to take this time to thank all of our sponsors for their participation in Day with DISA. Specifically, I'd like to call out CRL, our title sponsor for 3 years running. We'd like to thank our platinum sponsors, OraSure, Quest Diagnostics, Samba Safety, and Psychomedics. All of our sponsors' support is greatly appreciated. With that, let's get started. Enjoy your session.
Hi, and thank you for joining us for this session of Day with DISA. Today we're talking about transportation best practices. Today we've got two industry-leading experts. We've got Ben Johnson, who's got numerous years in the industry, previously with a company called Fleet Screen out of Fort Worth, and Tim Doyle, Vice President of the Maine Motor Transport Association. Ben, take it away.
Good morning, everyone. Thank you for attending our seminar, and for all of those that are attending Day with DISA for the first time, welcome. Thank you also to our sponsors. We appreciate all that you do. Today we're going to talk about transportation best practices, and I think we've all seen how important our transportation industry is in our country, especially with the recent COVID pandemic. With the essential services of trucking companies providing products and PPD to folks throughout the country has just been really important to keep the supply chain moving. And I think everyone understands that. In fact, the truckers have been embraced in the same manner as healthcare workers have during this pandemic, and just goes to show how much we appreciate them in our industry. And I've even heard some heartwarming stories about when the only restaurants that were open were fast food restaurants in several states, and truckers who were still driving goods and services were unable to go through the drive-through. Well, people were going out of their way to buy food for truckers during that time. It was very heartwarming stories, and we all really appreciate what they do to keep us all fed and clothed throughout this unprecedented event. We're going to talk a little bit about some best practices as well with all of the DOT modalities. We're going to also talk about some new regulations that started this year, the National Drug and Alcohol Testing Clearinghouse, and some new testing options that are on the horizon for 2021. But first, we'd like to talk a little bit about the Department of Transportation. Most people don't realize there's several modes of DOT, and I'm going to address each one individually. FAA is the Federal Aviation Administration, which, as we all know, as your airlines that travel all around the country, which right now isn't happening so much, but we depend on them for travel in our country and internationally. The FMCSA, which is Federal Motor Carrier Safety Administration, which represents the largest percentage of employees under DOT, and our program will have emphasis on that. The Federal Rail Administration also moves people and products through companies like Amtrak that haul people around, and commuter rails, and as well as hauling goods and products. The FTA is your local bus lines, generally speaking, community metro systems that transport people within a community. PHMSA is the Pipeline Hazardous Materials Safety Administration, which is regulates the transportation of gas. And the U.S. Coast Guard maritime industry, which is regulated under the Department of Homeland Security. All of those are listed, and you see each one of those sections that are listed on the slide indicate the safety requirements for each one of those modalities of DOT. Those are the specific regulations by mode that companies must follow to ensure compliance with the DOT and specific modality guidelines. Safety sensitive positions is the industry regulation, and a lot of this goes back to a couple of cases which were the catalyst for DOT testing. The Skinner and Von Raab cases back in the late 80s, where there was a large rail accident where a lot of people were injured and killed, and turned out that the employees that were operating the train were under the influence, and that's what promulgated the DOT testing guidelines. And interestingly enough, or ironically, those folks that were under the influence at the time were under the influence of marijuana. And here we are 31 years later, and there's topics about marijuana being legal in states, and we'll get to that as we move along towards the end of the program with Q&A. Talk a little bit about FAA, safety sensitive positions. You see on the slide there the specific duties that are regulated under safety sensitive for FAA. I can tell you that FAA is probably the most stringent of the regulators, and reasonably so, because they're transporting people around the country, and those audits are pretty stringent. So for those of you that are regulated under FAA, please make sure that you're aware of those types of duties that affect you and your company. Federal Motor Carrier Safety Administration, FMCSA, is the largest percentage, as I stated earlier, and will be the emphasis of our presentation today. We'll talk about commercial motor vehicles and commercial driver's licenses, and what you see on your screen right now are the instances when a driver is on duty or in commerce, which affects their safety sensitive position. We have Tim Doyle on the call today as well. And Tim, glad you're able to join us. Tim brings a lot of experience in the trucking industry. And Tim, would you like to comment on some FMCSA safety sensitive guidelines?
Thanks, Ben. It's a pleasure to join you and the folks with DISA today. As Ben said, essentially in the FMCSA realm for drivers, it's all time spent on duty and driving. Drivers are always subject to testing for drugs at any time, in fact, even when they're off duty, but they are only subject to alcohol testing when they are on duty, reporting to drive, or just completed driving. So we often get the question, you know, what is a safety sensitive function in the FMCSA realm? And it's essentially driving.
Exactly. And also for a point of emphasis on FMCSA, in FMCSA, you've got the large percentage of motor carriers in our industry transport goods, but we also have some that are regulated to transport people, which is our school bus drivers that are also regulated under FMCSA. So have a combination of those types of transportation services. Federal Transportation Administration, these are the, you can see on your slide, the types of individuals that are regulated under FTA. As I stated previously, most of your FTA are your local bus transport companies in larger municipalities, and even in some rural municipality areas, you have FTA vans and buses. PHMSA, safety sensitive positions. There's not a lot of operators in PHMSA across the country. The large percentage of people covered under PHMSA are the contractors for the large operators. There's thousands of those. And I know DISA owns a company that deals with that, where they ensure that contractors are in compliance. And I know DISA on the energy side has a lot of experience working with many of the major gas operators throughout our country. The cornerstone of your drug and alcohol testing program is your company policy. Tim, I know you have a template that you provide to your members for FMCSA, which is very helpful to them in promulgating a company policy for drug and alcohol testing. You want to expand upon that?
Well, we do. We offer it as part of the service that we provide here at the association in concert with AWSI as our certified third-party administrator. The basics of the policy is it has to explain who the DER is for the company. That's the person designated to answer questions from company drivers, from the public, and to interact with the third-party administrator in receiving results and also requests for testing. It has to list what functions are covered under the policy. That's your CDL drivers in the trucking realm. It has to denote where the clinic is, who's going to be used for specimen collection, and the types of drugs that are tested for. That's the DOT 5-panel test and alcohol in the trucking realm. Also, which tests will be performed. That includes pre-employment testing, random testing, the one we're most familiar with, follow-up testing, return to duty testing, and obviously pre-employment testing. Has to list what conduct is prohibited. That prohibited conduct comes right out of the regulation and is quoted in our policy as it should be in all your company policies. And it should list the EAP professional or program or substance abuse professional contact that the company uses. New in January of 2020 is the Clearinghouse requirement. So that's something that went into effect January 6th of 2020. We'll talk about in more detail later. And it has to list a signed acknowledgement from the driver that he's received and understands the policy, as well as printed educational materials that help inform the driver of what they need to know regarding the regulation and the health impacts on drugs and alcohol on their personal health, their well-being, and their interactions at work.
Great, thanks, Tim. There's also the specific regulation under the Federal Motor Carrier Safety Administration is 382.601, which is the employer's obligation to have a policy. There's 12 key bullet points in that section. So you motor carriers that are attending today, please familiarize yourself with those requirements. Very helpful. Make sure that you have those in your specific company policy. Types of testing. Pre-employment's pretty self-explanatory. When you apply for a position with a company under DOT, it's a requirement that a negative pre-employment test be received before the employee can begin their safety-sensitive function. Then in addition to that, after passing that test, they're subject to random testing throughout the course of the year, which is unannounced. And then the third one would be post-accident testing. Each one of the modalities has their own specific accidents that are considered qualified accidents under their specific guidelines. Reasonable suspicion is self-explanatory, is an employee exhibiting signs and symptoms of either physiological or psychological impairment. Return to duty is for those companies that after a positive test allow an employee that's been identified to come back to work after being interviewed by a substance abuse professional. They would require a return to duty test before they can come back, a negative return to duty test before they return back to their safety sensitive functions, and then be subject to follow-up testing, ongoing follow-up testing for a minimum of 1 year. We talked a little bit about pre-employment testing. Tim, did you want to add anything to that with regard to CDL guidelines?
I do, thanks. I often hear from members who confuse pre-employment testing. Think of pre-employment testing as pre-use as a driver. If somebody works for a motor carrier and is in a non-driving function, they've probably already filled out an application for employment and are an employee of the company. But if they're going to become a company driver, they need to take a pre-employment test as well as be qualified for the company as a driver, which may require filling out another application for employment consistent with the regulations. So pre-use as a driver is the way to go there, and not to be confused with returning to duty or return to duty testing. If someone were to work for a company, leave to go to work for another company, and then come back, they would be subject to pre-employment testing and not return to duty testing. Return to duty testing, as we'll learn, denotes that the driver previously tested positive for drugs or alcohol.
Exactly. Thanks for that clarification. That's very helpful. Random testing was the second type of test that we discussed, and safety-sensitive employees in each DOT mode should be part of a DOT random pool. And the percentages selection vary by DOT mode. In FMCSA, which is our concentration, the selection for controlled substances is 50% of the eligible employees over the course of a year, 10% for controlled substances and 10% for alcohol. If you're a multiple mode company where you have PHMSA and FMCSA, which we see a lot of, it's very important to make sure that you're using the correct modalities percentage guidelines, or there is also an option to select at the most stringent guidelines. Tim, you want to add a little bit on that?
Exactly. So with two modalities, if trucking, for example, is 50% for drug and 10% for alcohol, and another modality might be at 25%, as long as everybody in the pool tests at the 50% level, you're covered because it's the more stringent guideline has been suggested. Some modalities also don't test at all for alcohol, and so if in one of those modalities, as long as you're testing for alcohol, it would be acceptable.
Correct. You could confirm those at the most stringent mode.
Correct.
If you're going to do both into one pool. Also, I'd like to make sure that we emphasize that non-DOT personnel cannot be included in the DOT pool. It has to be a specific DOT company pool, and your non-DOT people should be in a separate pool for selection. With regard to selection frequencies, quarterly is the farthest that it can be stretched out over the course of a year. That would be 4 times. We see companies that do monthly and bi-monthly as well, but quarterly is as far out as it can be spread. Also, with regard to performing selections, computer programs are very helpful. You cannot use some examples that are unacceptable by DOT is pulling names out of a hat or using ping pong balls. It has to be reproducible is the key. You should be able to reproduce the selection upon a safety audit. When they come in a year afterwards, you should be able to show how you did it. And computer programs are the best way for doing that. Notification of employees. Once an employee has been notified that they've been selected at random, they should proceed immediately to the clinic for testing. I know over the years there's been some confusion about a 2-hour rule. Well, no, once they're notified, they should go down immediately. And also get questions from employers about, when I receive my selection notice, should I drop everything and send my employee down for testing? Well, the answer to that is no. As long as the information is held confidential, the employee can be sent as soon as they're notified during that selection cycle. It's very important that you spread out also your notifications. You don't want to get predictable with your random selections. You don't want to always be notifying your drivers at the beginning of every quarter. They'll start to know, okay, well, it's January, it's April, it's July, it's October. I better clean up before those periods. So you want to be unpredictable with those notifications back to your employees. Tim, you want to add anything to that?
It's also, I think, appropriate to space them out. I don't often hear from employees who are not picked for random selection, but I often get called from those who are picked once or twice in a year. And if the selections are not spaced out appropriately, for example, someone drawn in the first quarter is sent in mid-March, and then they're drawn in the second quarter and sent in early April, it doesn't feel like to that driver that he was selected twice in 6 months. It feels like he was selected twice in 2 months. So spacing them out helps with driver satisfaction. And also immediately is defined by the motor carrier. So in some cases, immediately might mean the driver once told should be there within an hour. And there are some parts in Maine where immediately might mean within 2 or 3 hours due to travel time. The appropriate thing is once notified, they have to proceed immediately, and immediately means right away to the greatest extent possible.
Right. I'd also like to add too, it's a best practice to make sure that when you do notify an employee that they've been random selected, don't send them down an hour before the clinic closes, because you're could potentially get into a situation where the employee may have a shy bladder situation, and the clinic could close, and then you've got a problem on your hands, because employees will be given 40 ounces of water during the duration of the time to take the test in order to complete a sample and provide a sample with 45 milliliters of urine. Tim, did you want to add anything to that?
No, I think that's right. I think giving drivers communication is the key. So if the drivers know what the process is, they know that when they're selected, they're being selected by regulations and what the regulations require. They're familiar with where the collection site is and what's going to happen when they get there. All of those things that you help drivers with during orientation and on the front end, save from drivers being confused and caught up in a process on the other end. And what we don't want to do is walk drivers into a refusal situation where they get to the clinic, they misunderstand what's going on, and they leave. If they leave after signing into the clinic without completing the test, that's going to be handled as a refusal, and refusals are treated just like a positive test.
Okay, the next type of test is post-accident testing. Again, each modality has its own incident that qualifies as an accident under DOT. And I've highlighted these sections for those of you that are in a specific modality to review with respect to what those accidents are that would affect your operations when a drug and alcohol test is required. I will say under FMCSA that it's an accident and involves a fatality, an accident where a driver receives a moving traffic violation coupled with someone being injured at the scene that requires immediate medical attention. The third criteria would be where a driver receives a moving traffic violation and the accident has been sufficient enough where one of the vehicles must be towed from the scene. Those are the three incidents that under FMCSA.
And importantly, Ben, it's I think appropriate to point out that you cannot use DOT testing for non-DOT purposes. So I often get calls from motor carriers who have drivers who want to volunteer for a test to prove that they weren't using drugs or drinking, or companies that want to test. And unless all the requirements are meant for DOT testing, you cannot test under DOT. And it can result in lots of problems. For example, at litigation, someone testing positive when in fact the test never should have been issued, or someone being terminated for testing positive when a test shouldn't have been issued. So make sure you understand when you can send them. If no one's died and there's not been a ticket issued, no ticket equals no test.
Exactly, Tim. And I had one motor carrier years ago that was just testing on every accident using the DOT form. And unfortunately for them, they got selected every January. The DOT, the FMCSA, selects 15% of the motor carriers to submit their MIS data forms that shows all the testing that's been completed the prior year. Well, unfortunately for this carrier, they got selected and they had 65 accidents on their MIS data form with only 200 drivers. So that prompted a federal US DOT audit. So that's one of the examples as to why you test only under the required circumstances. Refusals to test is the next subject we're going to discuss. The biggest one that we see, in fact, we had one last week, is an employer will send a driver down for a drug test to the collection site. And in this instance, the employee didn't go. And the employer contacted us and said, do we need to report this as a refusal? Well, on a pre-employment, no is the answer. On a pre-employment test, it's only a refusal once the collection process is started and the employee or donor that decides not to continue to stay to complete the process. So that's one of the primary ones that we see. You see that indicated on the slide here. There's also some other examples with regard to employees attempting to subvert the collection process, either through adulteration, where they introduce a substance into the urine to try and mask drugs in their urine, or substitution, whereby they would bring someone else's sample to pass off as their own. And also failure to cooperate with any part of the testing process. I know some folks that own mobile testing companies, and they tell me, they have drivers that are disagreeable, and I tell them, you're in charge there. If they don't cooperate with the process, that could constitute a refusal to test.
I think one thing too to point out, Ben, is that walk-in clinics are very convenient, but oftentimes there may be several people waiting in line to be tested. So not having an appointment may result in waiting. Drivers by nature are a little bit impatient, and if they leave because they think they've been there too long, that's going to result in a refusal. So sometimes making an appointment is helpful for the driver, and you can work in concert with your driver in sending them once notified.
Well, that's a great lead into our next subject, Tim. Thank you so much in selecting a collection site. First of all, I'd like to thank the folks from Concentra, which are one of our sponsors for Day with DISA this week through our segments, and also the folks from FormFox that help everyone with the electronic chain of custody form. We thank you very much. Medical facilities, occupational health are the primary facilities used in the trucking industry and also by the other modalities. Most larger metropolitan areas have multiple occupational health clinics available. You can check online to see what is closest. I know the folks from Quest, another one of our sponsors, have a search option on their website where you can find clinics that are in close proximity to wherever your terminal or office locations are. I also recommend that managers visit the clinics from time to time to make sure that people are being processed in a quick fashion. And I do know with occupational health clinics, they're there to treat injuries, so those are going to take precedence. So make sure you visit and see that your folks are getting through in a timely manner. And also speak with the management there at the clinic location and make sure that you're comfortable with the way things are being handled, and is it clean, and are there office hours amenable to your operations. Also coordinate with your consortium third-party administration. They can be very helpful in those instances. And recently, within the last 10 years actually, just goes back a little bit, on-site collectors. There's been a cottage industry of mobile on-site collectors that have emerged in our country. We find them often for after-hours post-accident testing. It might be helpful for you as a motor carrier to look into those options for them to come on site. If you've got a good drive to your clinic, if your driver's, if it takes 10, 15 plus minutes, it might make sense from an economical standpoint, since you're having to pay for random tests, having to pay the employees for their time for a random test, to have a mobile test provider come on site and do those tests. There's no interruptions. There's no injury care taking place. Tim, I know you've got one in your state that we work with. You want to elaborate on the mobile testing?
We actually have a couple up here, and they are, especially in times like this, during the pandemic and COVID, a lot of drivers are reticent to go to a collection site, and a lot of employers don't want to send them there. They're nervous. So we've experienced an uptick with people requesting a mobile collector for that reason. Also, a lot of our schools up here, school districts will tend to use them because what they can do is schedule 1 or 2 days and space their collections out right at their facility, where drivers are reporting to work, getting tested, and then ready to go right back to work without that downtime. So it is a little more costly, but not so much that it's probably not worthwhile checking out. And especially during COVID, might be a viable option for all motor carriers.
That's great. And DISA also offers nationwide on-site collection options throughout the country for anyone in DOT mandated modes or for non-regulated testing. Also, ODAPC, the Office of Drug and Alcohol Policy Control, I would definitely recommend visiting their website at odapc.gov. There is an overview of how to visit your collection sites and some questions to ask them. So make sure you take a look at that website. If you're a carrier or a DOT mandated company, it'd be very helpful for you in selecting and determining your collection site is meeting the guidelines. Also selecting a Health and Human Services Lab. Big shout out to Clinical Reference Labs, our key sponsor for Day with DISA, and also Quest Diagnostics. I've mentioned them previously. There's 22 labs on the certified list currently as of October 1st that are authorized to conduct federal workplace testing programs. And there's a highlighted link right there for those of you that want to look and see if one meets your needs on a more geographical standpoint. And I also recommend you reach out to your consortium third-party administrator with that selection process. They may have a good relationship with one of the labs that would be helpful to you with respect to selecting clinics and MROs. The medical review officer is the gatekeeper of the testing process. The medical review officer is a licensed MD or DO that is also been accredited by one of the national bodies, such as the American Association of Medical Review Officers, MROCC, or AOHC. They're an independent, impartial third party that has no affiliation with the lab, no affiliation with the clinic. I always state they're like an umpire calling balls and strikes. If a positive test comes in, they give the employee the opportunity to address the positive and determine if there's a legitimate medical condition that exists or if they're on prescription medication that may have triggered a positive test. And if it's negative, they report them through in a timely manner to the motor carriers so they can hire the employee and move forward. Tim, you want to talk a little bit about MROs and your relationships over the years?
Our experience has been excellent. Dr. Ben Hayes, who's now working with University Medical Services, one of DISA's companies, has always been there to answer questions. From a personal standpoint, he's been willing to take calls when drivers have questions that are medical of nature and a little bit outside my expertise. So he's been there both as a referral and also to talk to drivers as required by regulation. One of the things to remember is the MRO has up to 3 days after a test, 72 hours, to continue to try to reach the driver before reporting the test result out. So occasionally we have tests that seem to be hung up. If motor carriers have not received their test in 24 to 48 hours, I recommend that you start calling the certified third-party administrator to check on where the test might be. And you might find out that it's been received, but it's hung up at the MRO level. I wouldn't read too much into that. That doesn't necessarily mean it's a positive test, but don't wait. You know, sometimes a week or more, people will wait to call and say, hey, I haven't got the results. Check on them after 48 hours of not receiving them to keep the process moving.
Exactly, great points. And they're required to make 3 attempts in the first 24 hours to contact the employee. And if unsuccessful, then they reach out to the employer and ask them to have the employee or applicant for the position to contact them to discuss their test result findings. The role of the MRO with regard to the section in 49 CFR Part 40. Part 40 is the section that encompasses every one of the modes of transportation. Each one of the modes have their specific safety requirements for safety sensitive personnel, but 49 CFR Part 40 is the laboratory, clinic, MRO, SAP, all of the processes guidelines. And these subparts are listed in Part 40 with respect to the MRO's requirements under these guidelines. Consortiums and third-party administrators is our next topic. DISA is the original CTPA. I remember back when I started my first company in 1988, I really kind of based it on DISA and how they started. I was really impressive. They put an ad in the Wall Street Journal and were very successful at the beginning of the Drug-Free Workplace Act that was promulgated in 1986. And then in 1988, the federal workplace testing programs, DOT, DOE, DOD, all came on board. And DISA really timed that well. There's many CTPAs out there. Some of you may be on the call today that use another one. There's some really good ones out there. Just make sure they're following the proper guidelines because they stand in your shoes. If you cannot sign your compliance away. So make sure that you're using a TPA that you trust, that is handling all of the program from a turnkey standpoint. Random selections, working with your clinic on pre-employments and getting folks in for testing, post-accident coordination, laboratory selection, and MRO. Tim, you want to add a little bit about CTPAs and the ones you've worked with over the years?
Oh, just to reemphasize that although the motor carrier can assign some of these functions to a service agent and the third-party administrator, they remain as a motor carrier responsible by regulation for all of the actions. So having a good relationship is important. We work very closely with DISA and the related companies now, AWSI and University Medical Services. So having that relationship as a trucking company, for us as an association of trucking companies, is extremely important. I work with them every day as a result.
Yes, it's great. It's a one-stop shop. I can't imagine the headache it would take to hire the lab separately, hire your clinic and hire an MRO, purchase a random selection computer program and try and do all of those functions separately as a carrier when CTPAs have emerged over the years to provide that one-stop shop for motor carriers and those folks that are in other modalities under DOT. CTPAs, here's some, under Part 40, here's some requirements for the CTPAs with regard to guidelines they must follow with regard to assisting employers with meeting compliance. You can familiarize yourself with those sections and with respect to selecting the proper CTPA. There haven't been many, but over the years, there's a couple of them that have received a public interest exclusion where they haven't functioned as they should under the DOT guidelines. I think there's only been two since Part 40 was began back at the beginning of 2000. So it's very important that service agents follow these guidelines or they will be held accountable by the federal government. The substance abuse professional is an integral part of the program. If you have an employee who tests positive, it's your requirement as an employer to refer those individuals to a substance abuse professional to get help. You just don't say, sorry, hit the door, buddy. You have to, under DOT, you have to give them a list of SAPs where they can go out and get some assistance with their drug or alcohol problem. It's an integral component for the guidelines. And there are some specific regulations with respect to substance abuse professionals having certain qualifications, any MD or DO, and the social workers and psychologists. And there's also a list of some some certified personnel that can function as SAPs. Tim, you want to add a little bit about your association's involvement with SAPs or referrals?
Just to be careful about when selecting an SAP, make sure that they are certified and taken the DOT testing that are required. Quiz them a little bit before hiring them. Ask them if they're familiar with Subpart O of Part 40. If they're not, they are not a substance abuse professional by regulation. That's important to denote the difference between a medical doctor or maybe a licensed clinical social worker who could be a substance abuse professional, but not under the definitions in Part 40. I've had one instance in which somebody went for treatment for 2 weeks only to find out they weren't using an SAP certified by DOT. And although it probably wasn't wasted time, it didn't help them get back into compliance with the regulations. So a little bit of work ahead of time. There are not that many in Maine anyway, and my guess is probably not that many in most of the states.
Yes, and it's important to emphasize that even if a company has a zero tolerance policy in their drug and alcohol program, that it's still incumbent upon them to refer the employee out for help. Now, some employers do allow folks to come back after visiting an SAP, and we talked previously about the return to duty process and the follow-up testing process. Once the SAP has completed their analysis of the individual to determine whether it's a potential problem, if they represent a safety risk, they may or may not recommend treatment. If they do recommend treatment upon completion of that, and they feel like it's, the SAP feels like it's okay for the employee to return back to work, then they would refer them back for a return to duty test, which must be negative. And then after that, they're subject to follow-up testing for up to 1 year, 6 at the first 12 months. Moving on to the Clearinghouse, I was visiting some folks the other day and helping them clear out their pantry, and going through some products and looking at cans and bottles, and noticed a lot of them had a best by date. That's what we were using to determine whether we were going to keep those things or not. And Tim, I can tell you, January the 6th, 2020 was not a best by date for the Clearinghouse.
This has been one of the biggest issues that we've been dealing with here at the association. The Clearinghouse was well publicized with an implementation date of January 6th of 2020. That is the date that the law took effect, and is a starting date that kicks off some of the requirements for motor carriers. But some of the confusing aspects of it is, are companies in non-compliance if they haven't yet registered with the Clearinghouse? And the answer is maybe not. If you are a motor carrier who has not hired a driver since January 6th of 2020, and you've had no violations within your company, you are not in non-compliance yet, and you don't have to register until you're required to perform your first annual query, which is not due till January 5th of 2021. However, if you've been hiring drivers since January 6th of 2020, you are required to register, because drivers are not eligible to operate until you've received a query report back from the Clearinghouse. So the other question that comes up is, are all drivers required to register? And the answer is no. If you're a driver who has been employed by the motor carrier prior to January 6th of 2020, you are not required to register with the Clearinghouse. The only time a driver needs to register is if they want to see their own information in the Clearinghouse. They're required to register to do that. If they have a violation that needs to be reported to the Clearinghouse, they're required to register. And if they go job shopping, looking for another job, they'll be required to register. Other than that, to have an annual query performed on them, which is a requirement, they can simply sign an annual query consent form, which is just a wet signature that the motor carrier keeps in their DQ file, and allows the motor carrier to search on them at least once annually for purposes of complying with the Clearinghouse. For new drivers coming to work, it is incumbent upon the driver to get registered, But I think motor carriers share a responsibility in helping them register. Since they can't work until they've been cleared through a pre-employment query, it's incumbent upon the motor carrier to assist them. Some pitfalls we've seen are motor carriers trying to use a company email address for the driver to register. Because that's a driver requirement, they should use a personal email address, since their clearinghouse registration will follow them from company to company that they might work for. So no need to panic. If you haven't hired anybody or had a violation, get registered soon as time is running out, and make sure your first annual query is performed no later than January 5th of 2021. Once you do your first limited query, that sets the date for the next limited query, since they have to be done at least annually. So if you performed one in June of this year because you thought you had to, make sure your next limited query is performed no later than next June to stay within the 1-year time period. And just a sort of an industry recommendation, we think that most annual queries should be done the same day you have to do your annual check of your motor vehicle record. That's another regulatory function you have to perform once annually, and doing them on the same date for everybody in your company is a best practice.
That's great. It's, you know, an anniversary type. I know that I go see my physician every year on my birthday because I know it's coincides with that. So that's a very good, helpful point. Also, you know, some of the clearinghouse is long overdue. I know it's been going through the government regulations for years, but we've seen it in some states, like in Texas, has their own clearinghouse that they've had over the years. It's been very helpful. I know back when I started my first company, it was very shocking to us to see a truck driver test positive for cocaine and get terminated by that employer. And then next thing we know, we see them applying for a position as a school bus driver. And there was nothing we could do about it. So, you know, here we've got somebody who's tested positive for cocaine now driving kids around. So the clearinghouse will eliminate those types, or to the best extent possible, eliminate those types of situations to where a driver will need to get help before they can return back to performing a safety sensitive function. We talked a little bit about what the clearinghouse will contain and the types of tests, and refusals to test also should be reported to the clearinghouse, not just positive tests. Talk a little bit about the entities. We talked about the employers and registering on the portal, and that the drivers also have to register. So do the medical review officers and substance abuse professionals, and CTPAs, Consortium third-party administrators, as well as state driver's licensing agencies. Tim, you want to touch a little bit on those types of entities that are subject to registering?
Well, from the aspect of the employer, one of the things that employers need to know is if they don't assist the driver in registering, the clearinghouse actually sends a letter to the driver's last known address if they're not registered. And so as an employer, when you're hiring a driver, you want to get them on the road and moving. And that can't happen until they're qualified. And one of the things that has to happen now is that pre-employment query. So if a letter was to be sent, it could take weeks to a month to get that request out to the driver and back. So assisting them is just really imperative in making sure that they can get to work as quickly as possible. The other thing I'd like to mention is motor carriers are still required to do the investigative inquiries of the previous employers, anybody that the drivers worked for in the last 3 years. That's a different segment of the regulations, but that requirement in Part 391 will go away 3 years from now once the clearinghouse contains 3 years worth of violations. Today, the clearinghouse only contains violations that occurred after January 6, on or after January 6 of 2020. So a violation that happened in December of 2019 will not be in the clearinghouse, and you need to follow the former regulations for dealing with that issue.
That's right. And I saw after the first 6 months, there was a report back from the clearinghouse on the number of positives that had been reported, and it was quite high. I can't remember the number. I think it was in the thousands. So it's very important that we identify these drivers, get them help, and see if we can get them back to work if possible. Thanks, Tim, for adding that information. That's very important with respect to the employment verifications continuing for 3 years. Let's talk a little bit about some upcoming issues that we see on the horizon. I know the new chain of custody form, which was set to go into effect on August of this year, has had a delay for another year. Primarily, the new chain of custody form is going to have the state driver's license number. That's the biggest change on the form under ID. Presently now it says Social Security number or other ID. We're moving, because of the Clearinghouse, to a new form which will capture the state driver's license information so we can match it up with the Clearinghouse data. And then in addition to that, we suspect that hair testing will be coming down the pike. I know we've got the folks from Psychomedics and one of our sponsors, and Omega as well, Omega Labs. We appreciate all that you do, and those folks are on the forefront of hair testing, and I know DISA is as well. We perform hair tests for many of our customers. What's going on now with the federal motor carrier and the other modes of transportation, the only authorized means of testing is urine. And some larger fleets have been testing for hair as a non-DOT testing requirement, and the positivity rate is much higher with hair testing than it is with urine. Tim, you want to talk a little bit about that?
Yeah, I think the positivity rate's higher because drugs stay in the hair much longer than they stay in the system. So, you know, a company, when hiring a new driver, maybe getting somebody who uses drugs, may avoid using it for the 2 to 3 weeks prior to getting tested, and may or may not test positive in a pre-employment test and go back to using drugs. So it's just a much better ability to capture a drug user and prevent them from entering a company as a result.
Most definitely. Thanks for bringing that up. And as a point of reference as well, hair testing will not be authorized for triggering event type of scenarios such as reasonable suspicion or post-accident, because the hair has not grown out sufficiently to tie it to the event. So that's one thing to be aware of. We always caution companies when they have a triggering event that want to do hair testing that no, you want to do oral fluid or urine to try and tie it to that event. And that's a good lead into oral fluid testing, because that particular type of test, which is saliva based, picks up the most recent use of drugs. And I was amazed when I found out from Dr. Sample at Quest that their positivity rate with oral fluid is higher than it is with urine, even though the oral fluid window of detection is much shorter. It's like 24 to 36 hours. And I think you're going to see that come down the pike as well with US DOT and HHS in the coming months or year. Well, folks, that wraps up our program, and we'd like to take some questions at this time. Thomas, are you available for some questions from the audience?
Of course. No, hey, thank you so much, guys. That was absolutely great. Extremely impactful. We're going to dive into questions really, really quick here in just a minute. I just want to call out 2 real quick things. One, if you'd like a copy of this presentation, Ben and Tim made it available to us. And so we put that down at the bottom right in the materials link. Anyone can click on that and they'll be able to download this presentation. And 2, I know we're running short on time for questions here, but ask your question down in the Q&A section at the bottom right. And if we don't get to it today, we'll have someone reach out and try and answer for you in the near future. So we're going to fly through these as quick as we can, Ben and Tim, and see how many of these we can answer before we run out of time here. How do you recommend dealing with drivers who take CBD oil?
Well, the ODAPSI I mentioned previously, odapsi.gov, actually there's some guidelines on CBD use. It's kind of like the wild, wild west. The FDA packaging requirements do not really specifically indicate what the percentage of CBD or THC is in that CBD product. I know in the states where marijuana is illegal, CBD is at 0.03. And in most cases, the individual should pass the DOT test in those states. But in states where it's legal, marijuana is legal, you're going to see all sorts of different levels of CBD. So buyer beware, caveat emptor when purchasing CBD.
Great. Thanks. Tim, anything to add?
We get that question probably once a week, not so much now, but when marijuana issues were big in Maine. In fact, marijuana is become recreational legal in Maine. CBD oil is not in and of itself the problem. The fact that it contains THC or could contain THC is the problem. So it is buyer beware. It's not regulated by the Food and Drug Administration. And I've had several drivers call me thinking that they were taking a THC-free CBD oil and ended up testing positive. So buyer beware.
Perfect. So I know we talked a lot about the Clearinghouse, and there was some confusion around it last year and when it actually went into play, or when someone was required to take action. Is there any chance that that January 2021 date is delayed?
My opinion of that is no. I've seen the federal government delay a lot of things. They're kind of famous for that, but I think we're so far down the path now that the Clearinghouse is here to stay. It is proving to be valuable in finding people who are impaired and prevent them from driving. The problem with it is it's been a very difficult implementation. Motor carriers are required to have a portal account. The portal account with FMCSA has been difficult to set up, was not working well early in the process soon after January 6th, mostly because I describe it as trying to pour a 5-gallon pail through a very small funnel. So many people were trying to register after January 6th that it bogged the portal registration system down. Our experience has been it's working pretty well now, and it only takes about 15 minutes start to finish to open up your portal account and register with the Clearinghouse. And so now's the time. So January 5th is not that far down the road. If you're not registered, you should get registered. Make sure you know how to perform your queries and get ready to do your first limited queries no later than January 6th. Again, whenever you do those queries, that starts your date for the next annual query, due no later than 1 year from then. And you can do them more often, but they have to be done at least once annually.
So 2 other questions relating to the Clearinghouse. Are there penalties if my drivers aren't up to date? And can I do this myself if I'm an owner-operator?
So the answer to penalties is I'm sure there will be. We've not seen, I've not seen any violations written, but I know that during compliance reviews, the auditors are inspecting whether or not you're registered and whether or not drivers have received a not disqualified query back prior to driving. So I'm sure there'll be penalties. I'm sure they'll be monetary in nature. I'm not sure what they are yet. And in terms of an owner-operator, the owner-operator acting as the motor carrier can register in the Clearinghouse. They have to meet all the requirements of an employer and an employee. So they would register as the employer, also list themselves as an owner-operator. The only thing that they can't do and need a service agent for or a third-party administrator for would be to administer a return to duty process and follow-up testing. Because those have to be scheduled and have to be unannounced, they have to be handled by somebody else. And they're required to engage a certified third-party administrator to do that for them. They can, however, perform their own queries, or they can use a certified third-party administrator to do that work for them.
Well, hey, I know we're right up against it. Tim Doyle, Ben Johnson, thank you both for taking the time out of your busy days to present this.
Thanks, Thomas. Thanks, Tim. Thanks, everyone, for attending. We appreciate it. Let us know if you have any questions.